Good day, everyone. Welcome to AWM or Ascot Estate Planning's webinar series. Today we'll be talking about bloodline planning, and our host today is Laura Ford. Without any further ado, I'm going to hand over to Laura. Please enjoy the webinar.
Hi everyone, so as Issa said, I'm Laura and I work for Ascot Estate Planning, which is the sister company to Ascot Wealth Management, and I do all aspects of estate planning. So we do wills, trusts, powers of attorney and some corporate work too, but today we're going to be focusing on bloodline planning. I'm hoping this will be helpful for maybe any new clients that don't know what bloodline planning is, don't know much about trust. I'm hoping this will be useful, but also maybe for some clients that maybe completed their bloodline planning 10 plus years ago and doesn't remember why they have any of these trusts. I'm hoping this will refresh your memory and be useful for you as well. So we're going to start actually by talking about wills and then move on to bloodline planning. So generally when someone comes to me and they maybe have never written a will, or they have a will that's just out of date and needs to be redone, I say, well, we have two options really. We either do a simple will or we do bloodline planning where we add in trusts and make it a bit more sophisticated. They're both valid options, so we always talk through both. So we will start by talking through wills. So why do you even need a will? The purpose of your will really is to direct your estate to whoever you want to leave it to direct all of your belongings wherever you want them to go. And in your will, it's just worded as my estate. So it's everything that you own when you die, with the exception of pensions and life insurance, which pass separately through the providers. But otherwise, it's just worded as my estate. So your will doesn't list out all of your assets. You don't have to keep it updated in that way. Your will covers everything. And that's the main purpose of your will, to direct that estate. And in the UK, we have testamentary freedom. So you can leave your estate to whoever you want to. We don't have any enforced inheritance or anything like that. So it's important to write your wishes down. Your will also name executors. So executors are the people that do all of the admin when someone has died. So they will apply for probate, pay any inheritance tax if it's due. They'll submit accounts to HMRC, and then ultimately give everything to the beneficiaries, and then that's their job done. You do have the option to name professional executors, but obviously they charge, and they can charge a percentage of the estate, kind of up. So we usually recommend a friend or relative if you have that option. You will also in your will name guardians. So if you have any young children or children under 18, you will guardians people to look after them if something happen to you. So if one parent dies, parental responsibility automatically passes over. We always recommend a guardian in case something happened to you together. And we can also take reserves as well. So people often name grandparents first guardians, and also take reserves in case your children's grandparents predeceased them. So they're big ones. And also your will, it will come legacies. So if you have any specific items like sentimental things like jewelry that you want to go somewhere specific, that will go in your will. Or if there's a person or a charity that you want to receive a smaller monetary amount rather than a percentage of your estate, that will go will. We'll also ask you things like funeral wishes, organ donation, and if there's anyone you want to specifically exclude from making a claim against your estate, which a lot of people do. But if you have any ex-partners or strange children that you think might try to make a claim, you can specifically exclude them and put that in writing in your will. So moving on, if you don't have a will, what happens? So if you die without leaving a will, that's called being intestate, and law sets out who will receive your estate in that scenario. So it goes in this order. So if you're married without children, then everything is passed to your spouse. If you're married with children, the first 322,000 pass to your spouse, and the remainder is split equally. So 50% goes to your spouse, 50% goes to all of your children in equal shares. And note in both of those, it says married. So you have to be married. Any sort of long-term partners or cohabiting partners don't receive anything under the laws of intestacy at the moment. So it's only spouses. If you don't have a spouse or children, then it passes this order. So it goes to parents first, brothers and sisters, nieces and nephews, grandparents, and of course cousins. And ultimately, if you don't have any living relatives to take your estate, then it passes to the crown. So if you have a will and you're thinking about when to update it. We do recommend reviewing them like every 5 or 10 years to make sure you're still happy with the individuals that you named in there, like amazing executives and guardians. That's important just to make sure you're still happy with that. Otherwise, if you get married, that's definitely a time to update your will, because marriage revokes any will that you've written previously. So that's definitely a time to update your will. Similarly, if you get divorced, that would be the good opportunity to make sure your will's up to date. If you have children, then that would be definitely a time to do your will, to name the guardians I've discussed before. And also, just if there's any significant changes to your estate, like if you purchase property or you receive inheritance, if there's any big changes to the makeup of your estate, that's when we recommend doing your will. That's all, everything in a simple will. And now I'm going to move on to bloodline planning, which is where you write your will, direct your estate into trust. And we use that only for asset protection, which is not the same thing as tax planning, but they can interact. The idea is that you're preventing the asset you leave to your beneficiaries from forming part of their estate. So we're trying to keep it separate from their estate, and then separate from any of these risks I was going to discuss. So I'm going to start by talking about planning you would do for a married couple that's under the nil rate band. Any person can do this type of planning, whether you're a single, married, regardless of estate status. But we're going to start with the scenario. And here we've just got the risks of a simple will. So let's use me as an example. If I make my will, leave everything to my husband, then on my death, everything to my husband's name, and he owns the entire estate at that point. It's called passing to him, absolutely. So it forms part of his estate and he owns everything. First risk is if he needs to go into care in the future. Then when the local authority does their means assessment, the entire estate is in my husband's name. And care is very expensive, especially around here, so the estate can be depleted quite quickly that way. So care is a big one. The other one would be remarriage. So if I die, leaving everything to my husband, and one day he remarries, what can happen is if he writes his will, leaving assets to his new partner, my children can lose out. That's called side-based inheritance, where my husband rewrites his will, leaving assets to his new partner, and then he dies, and his new partner, their will doesn't cover for my children. They end up not receiving the inheritance I would have wanted them to. And then thinking about children, so say in this scenario, both me and my husband died, leaving everything to our children ultimately, and it again forms part of our estate, it belongs to them. Things like if they get married and they go through divorce, then everything we've left them, 50% that could be lost in a divorce settlement, or they have credit claims if they start their own business and have any credit claims. It's really any third party claims we're trying to prevent here. Another one is generational inheritance tax. So I said on the previous slide that this isn't tax planning. Bloodline planning doesn't change the inheritance tax position on your death. But what can happen is if you, like I said, do your simple will, leaving everything to your children, and then at the point of your death, say they already have built up their estate and they're on the nil rate band or over the nil rate band, what you've left them will get taxed, will add on to that and get taxed on their death. And that will keep happening down the bloodline. So those are the things we're trying to prevent. So if we look at this next diagram, so as I said, this is the planning we would do for a married couple that's under the nil rate band. So there's not an inheritance tax problem here. It's an under the nil rate band. So we'll come on to the over the nil rate band planning after this, but let's just keep it simple for now. So what this diagram with the house is showing is that you would firstly sever the tenancy of your property. So if you're married and you own your main residence, it's most likely that you own that property as joint tenants. That's the most common way that married couples own property. And that means that when you die, your half automatically passes to the survivor. So it doesn't pass through your will. It just automatically passes by survivorship. If that was the case, we would change that. We'd sever your tenancy with the land registry, and then you would become tenants in common, which means that you own 50% each. And we want that to happen because when you're tenants in common, it looks to your will to see where you've left your 50%. It doesn't automatically pass to the survivor. It goes through your will. We want that to happen because what we're going to do is write your wills. They come quite simple. They have your executors, your guardians, funeral wishes, those things that I mentioned before. The point of beneficiaries is of saying my husband, my children, everything is left into trust. And in this scenario, it's one trust each. And the way it works is that 50% goes into trust. Or on, let's use that example again. I die and I've left my 50% of the estate into trust with my husband. And let's take that first scenario where in the future my husband needs to go into care. And when the local authority are doing their means and they're looking at what my husband has, he owns 50% of the estate and 50% of the estate is owned by trust. And anything that is in that trust is not included in my husband's means assessment because it doesn't belong to him. And with the main residence, which is often the largest asset for a lot of people, how it works is that when the local authority doing my husband's means assessment, they have to take the open market of his share at the time he's going into care. The precedent here is that you can't sell half of the house, so his 50% of the property is valued at zero and the entire main residence is protected. So any sort of cash investments, pensions in my husband's own name can be used to pay for his care, and they would be. There's not much we can do to prevent that. But anything that I've left into the trust, my own savings, investments, etc., are protected, and the entire main residence is protected from using that trust. And then coming on to the remarriage scenario, so I've died, leaving my 50% of the estate to trust, and my husband remarries. He can rewrite his will to leave his 50% of the estate to his new partner if he wants to. But my 50% of the estate that's gone into trust can't be left to anyone else. It's always going to go down to my children. It will only benefit the beneficiaries that I've named in the trust. So my half is protected in that scenario. And then coming on to children. So say now that me and my husband have both passed away, so 100% of the estate has gone into trust, two trusts because we have one each. And then my children take money out of the trust, and then say they go through a divorce or they have any creditor claims, that money is protected. And the way that works is that we recommend anytime a beneficiary is taking money from a trust, they take it as a loan. So say my child wants to take out £100,000 from the trust, for example, because they're doing up their house, they're doing some work to their house. That's fine. That can come from wherever it's held in the trust. If it's being invested, perhaps that can come into my daughter's bank account. But there's a loan document that says the trust is lending this £100,000 to the beneficiary for their lifetime. There's no interest due or anything like that, but it's due back into the trust on their death. And that loan document is what keeps that money from forming part of the beneficiary's estate. So in that scenario, a child has taken £100,000 out of the trust and then they go through a divorce or they have any creditor claims, legally that £100,000 doesn't belong to them. It's a debt on their estate, so it's protected. And that's the same with this generational inheritance tax. So thinking years in the future here, but leaving money to your children and then them passing away. So like I was saying, if they've taken that £100,000 out of the trust or any amount, I'm just using £100,000 for ease, then on their death, that £100,000 is a liability on their estate and it has to be paid back to the trust before their own inheritance tax bill has been paid. So it prevents that generational inheritance tax. I'm going to show you now how this structure changes slightly when we have a married couple that is over the nil rate band. So if we have a married couple where we know there's going to be an inheritance tax liability on their death, what happens is we add in another type of trust. So you end up having 4 trusts in total. So that's 2 trusts each. You have what's called a flexible family trust, and that collects your nil rate band and your residence nil rate band. So that's your inheritance tax-free allowances. They go into that trust. And everything else goes into an interest in possession trust. So the residue goes into an interest in possession trust. The trusts themselves are probably going to be really similar. You're almost definitely going to have the same trustees and the same beneficiaries across both of them. The reason we separate it is to allow you to claim your spousal exemption. So when you die and you leave everything to your spouse, there's no inheritance tax on that transaction. It all gets delayed until the second death because you get a spousal exemption. And we want that to happen because if there were, say, 10 years between first death and second death, we can look to do inheritance tax planning there to mitigate it as much as possible. So there's another type of trust that's added in when you're over the rate band. Also, when you do trust planning as opposed to a simple will, we draft what's called a memorandum of wishes. So this is where you get a bit more control and flexibility than you do when you just have a simple will. With a simple will, you can say, I want my children to receive everything at this age 18, 21, and that's it. That's the amount of flexibility you have, really. Whereas with a trust, you have a bit more control. So you write a letter to your trustees saying how you'd like the trust funds to be used, and people primarily use this for age restrictions. So you can stagger the age at which children or your grandchildren receive their inheritance. So the example I've given here is, okay, they can have university fees at 18, they can have a deposit for a property at 21, but can't have everything until they're at 25 or 30. And people do that. That's quite a common way of doing it, but I've seen people do it as percentages. So saying they can have 20% of their inheritance at 18, 50% at 21, and then 100% at 25 or 30. But you have so much flexibility there. Some people would use this to use the trust given income to the beneficiary for a certain amount of time. If they can take a larger amount out, you have flexibility there. But it's important to note that this document is a letter of wishes. So it's guidance to your trustees. It's not instructions. The way this planning works, all of those trusts I just explained to you, they're all discretionary trusts, which means ultimately your trustees have discretion as to when your beneficiaries receive their inheritance. So that's sort of what keeps the money outside of these beneficiaries' estates, is that they don't have an absolute right to money. It's all at the trustees' discretion. So you can write, you can put in quite a detail around your wishes, and your trustees have to show that they've given consideration to it, but ultimately it is just a letter of wishes. And lastly, just a bit about the practicalities of a trust. So if we're drafting trust for you, you will always be first trustee of your own trust. That means that you can change anything during your lifetime. You can change the trustees and change the beneficiaries. Nothing goes into these bloodline trusts until you die. So you keep everything in your estate until death, and you will be trustee when you're alive to make changes. But then on your death, we need to have at least 2 trustees ready to step in and act, because you always need 2 trustees. That's just trust law. A trustee can never act on their own. They have to act with another trustee to prevent them acting in their own best interests, and they have to act unanimously. So they have to agree on everything. And beneficiaries and trustees can be the same people. They often are, if you have adult children that are happy to act as trustees. You trust them, and as long as they get on okay, like they have to act unanimously, that often works really well. You can name professional trustees. Of course, they have charges every time they have to act, which can add up. So you usually say if you have friends or relatives, go down that route, and then they can always go and get professional advice if they need to. Another part of trust law is that trustees always have to act in the best interest of the beneficiaries, which means that you're never going to be in a situation where a trustee just blocks one of the beneficiaries from receiving their inheritance. That wouldn't be possible. They have to show that they're always acting in the best interest of beneficiaries, and if for some reason they're preventing a beneficiary from making money from the trust, they have to show really good reason to do that. And lastly is just that trust can hold any kind of asset. So they can hold property, cash, investments, business shares, anything that you own can be passed into a trust. So I hope that was helpful. We're going to do some questions. Obviously, this is going out as a recording, so if you do have any questions on this, you can email me and we can arrange a call. Otherwise, thank you for listening.
Thanks, Laura. That was a very amazing presentation from you. We will be adding the recording onto YouTube, but we'll send it via email so everyone will get this recording. And the questions will be in the comments, or they will email the questions to Laura. So once again, thank you all for watching. Thanks, Laura, for presenting, and have a good day further.
Great, thank you. Bye.
Bye.